I think people want to know how all this works. So, but I got to move on to Jeff Lerman. And Jeff, thank you for waiting. We've got about 20 minutes for you to speak. But before we move on, I just want to introduce Jeff, which is that I've known Jeff for several years now. He's been really fantastic in helping us on our California efforts, especially in Silicon Valley. Great real estate practice. He probably knows most of the people in that, or a great group of people in the Silicon Valley area when it comes to real estate. And it's a fascinating dynamic that goes on in that area. But Jeff has some very interesting perspectives that may dovetail a little bit into what Jeff Michelle was talking about with regards to the real estate market and where commercial leases are going from here. So Jeff, do you want to take over and give us your background, introduction, and then go from there?
Absolutely. Thank you very much. Appreciate it. It's a great program. I've been listening to most of it, and great information. Now, can you, just to make sure you're seeing everything, are you seeing my slides?
Yeah, it looks great. Yep.
Okay. So we're going to be talking about best practices for COVID-19 commercial lease challenges from the landlord perspective. Because I'm an attorney, I do need to read a brief disclaimer. The webinar is for educational purposes only. There is no attorney-client relationship between myself and you solely by virtue of your receipt of this information. Any actions with regard to the information contained in this seminar should be undertaken only upon the advice and counsel of a competent legal professional. As Marty was saying, I am the real estate investors. I'm an unusual lawyer in that I'm the real estate investors lawyer, and I'm also a real estate investor and also a principal in a family office. That's important because a lot of years ago, I asked our clients why they hired us and why they continue to use us. And the most common answer I got was, we like the fact that you do what we do, that you're a real estate investor, so you understand what we do, you understand how we think, how we feel. And because I got that answer so often, and by the way, here's a testimonial from one of our clients who states it perhaps best. He says, I've used Jeff to handle both contract and litigation matters. He understands exactly what I'm trying to accomplish. He grasps the situation. He understands quickly what I want and need. Unlike other attorneys I have worked with, I don't have to waste time educating him. I appreciate that more than anything. And so if you go to our website, you will see that our tagline for our law firm is, we understand, we are investors too. I help investors with their transactions and litigation. I'm also past president of our bar association. I've been included in super lawyers for multiple years. I am rated AV preeminent, highest rating possible by Martindale-Hubbell, highest rating possible by Avo, 10 out of 10 superb. And I'm also a commentator on TV, radio, podcasts, and news. You may have seen me on Squawk Box or Fox News. In any event, let's get into it. This is an important time in commercial real estate history. Why this commercial real estate industry challenge is unprecedented and why you should care, according to a great article by Deloitte. I quote, unlike past economic challenges, COVID-19 is having an immediate and widespread impact on the commercial real estate industry across the globe. As a rule of thumb, the industry has historically lagged the broader economy by 6 months in terms of experiencing the effects. And that's important because in the past, we've seen something coming so we could prepare. In this situation, we could not see this coming and having the impact that it has had. But the expansiveness, depth, and unprecedented reach of this pandemic has started impacting the commercial real estate industry much sooner. Rather than the typical lag, the CRE industry was affected immediately. This was because trade activities and occupiers' businesses were shut down. And so because of the unprecedented nature of this problem, these new challenges demand new solutions. The new challenge is quick evictions are difficult due to orders, laws, and court closures. The new solution I submit to everybody listening is that you need a new mindset. Now, I'm a litigator as well as a transactional lawyer. And so in the past, when we've been hired by a landlord to go after a tenant who's not paying rent, we will start the litigation process fairly quickly and be aggressive in our pursuit of that. But right now, with what's going on, that approach can't work. It can't work because of what's going on in your state, our state, and I know we have people here from all over the country. So the new mindset is to seek the best compromise possible. So with that background, with that context, here's the problem. The problem are the tenants are facing an unprecedented and unanticipated economic hardship and uncertainty, and are still obligated to pay rent and are fighting for the very existence of their business. Landlords, on the other hand, are also facing an unprecedented and unanticipated economic hardship and uncertainty. They're faced with rent defaults, economic hardship, and uncertainty. They're still obligated to pay their mortgage and building expenses and are not in a position to become effectively a lender to their delinquent tenants. Not only that, but for many of you who are landlords, you may have investors in your deal, and you have a fiduciary relationship, a fiduciary responsibility to your investors to protect them and make sure that you're doing your job. So you're dealing with both the tenants and with not only your own situation, but also trying to be a good manager for your investment. So our purpose in the limited time I have today is to educate and provide an action plan for those of you who find yourself in this position. So we're going to talk a little bit about the pre-negotiation process, the actual negotiation, and the documentation of a solution. So first and foremost, we need to understand the tenant's motivation. And probably the most important part of that is that, at least here in California and perhaps in your state, you cannot begin the eviction process. Not now, not for quite a while. Tenants know they can't be evicted if they don't pay rent, because here in California, there's an emergency rule that's applicable to civil matters. And that rule prohibits courts from issuing a summons on an unlawful detainer complaint until 90 days after the state of emergency related to COVID-19 is lifted. The only exception is for an unlawful detainer action necessary to protect public health and safety. So that's really important. If we don't anticipate generally in California that there is going to be that the state of emergency is going to be lifted for maybe even another year. And so if that's what we're up against as landlords, that's potentially a problem. The other rule is that there is a stay against any action for judicial foreclosure, and it tolls any statute of limitations for filing such action until 90 days after the state of emergency is lifted again. So that's what we're up against. So given all this, you have to ask yourself as a landlord, what is the tenant's motivation if they, for whatever reason, either they're still in business, but their business has gone down so they can't afford to pay all the rent, or they are a business that is shut down. We represent landlords and tenants, by the way, in these kinds of restructuring, these commercial lease restructurings. And so if any of you are also tenants as well as landlords, or either or, we understand both sides of this equation, but I'm assuming that most of the people listening today are landlords. So we're focusing our conversation on that. So if you understand that this is what the tenant is up against, how can you go into a negotiation to deal with it? Well, the good news is that landlords can still sue tenants for money damages. And that's why tenants are coming to the table and they're dealing with us landlords. So let's talk about what happens if the tenant stops paying rent. First and foremost, you have to get an attorney involved early on. The problem is, respectfully to all of you, that if you are not a lawyer, you simply don't know what you don't know when it comes to this negotiation, and there's a lot at stake here. Some of these leases have rents, have income that can go into the millions of dollars. It depends on the tenant, but even on the smaller tenants, it's still thousands, tens of thousands, hundreds of thousands of dollars. And whatever money you might think you can save by trying to do this yourself, it's being penny wise and pound foolish, because when you make a mistake in this negotiation or in this process, it's a mistake that can ultimately cost you a lot more than whatever you might be paying for attorney's fees. So you want to get an attorney involved as soon as a tenant tells you, look, I'm having a problem, or as soon as you see that the tenant is not paying their rent. The next question you want to ask is the tenant collectible? You know, the first thing I do as a litigator when somebody comes to me and says they want to sue somebody because they believe that there's the person that they want to sue has committed some sort of impropriety, the first thing I ask is, how do you know the tenant's collectible? Because the last thing you want to do is invest a lot of money in legal fees, because that is what it is, it's an investment. If it turns out that even if we can get you a judgment that you won't be able to collect, what's the point? So first and foremost, you need to get some sort of understanding, and an understanding based upon facts that you can accumulate either through an asset search or just through communications with the tenant to determine if in fact the tenant is collectible. Let's assume that the tenant is collectible. The next thing you want to do with the lawyer is gather all the relevant documents. In most cases, that's going to include the lease, your loan documents, the vendor contracts, the financials for the tenant, also your financials for your property. Those are the most important ones. There might be others. Every deal's unique. Next, you want to evaluate your contractual obligations, both yours and the tenant's, both monetary and non-monetary. Every lease is different. Yes, there are published forms out there, but even with published forms, whenever I'm dealing with a published form, I always make changes to it. So you can't assume that one size fits all when it comes to a commercial lease. You need to take a look at the lease, and more importantly, again, you need to have your attorney take a look at the lease and help you understand it, because these leases are written by lawyers for lawyers, and you may not understand what you should be looking for in that lease to really understand what your options are. Next, you should develop a best case, worst case, and mid-ground projection for how this thing can unfold, because this is part of the pre-negotiation process, trying to understand what your options are. There are always options, and that's one of the things that we do, is identify those options and help you understand it. Next, and perhaps most important in this pre-negotiation process, is to get a pre-negotiation agreement with the tenant. Now, we were doing a lot of this back in the last downturn for loan workouts, where the lender was asking the tenant to sign a pre-negotiation agreement. And so we were negotiating a lot of those pre-negotiation agreements, either if we were representing the lender or the tenant. But in this context, you also need, as the landlord, a pre-negotiation agreement with the tenant. And these are not that long of a document, but they are very, very important, something that you really need if you're going to start negotiating. What terms are included in this are at least the following: a statement that the tenant agrees and represents that the landlord is not in default, never has been in default, to make sure that before you start entering into a negotiation where the tenant is asking for concessions, that you can be comfortable that if you do agree to a deal with the tenant, that the next day the tenant's not going to turn around and sue you, claiming that you are in default under the lease. That's the last thing you want. So it's really important to get the tenant to agree up front that the landlord, that you are not in default. Secondly, you want to make sure there's confidentiality, especially if you've got a property, let's call it retail, but it could be office, it could be any kind of commercial property with other tenants in it. The last thing you want to do is have your tenants start talking to each other and say, hey, I negotiated with the landlord and I got this deal, that deal, whatever. So you need a really strong confidentiality clause. Next, you want to make sure it's clear that whatever conversations and discussions and negotiations you have are non-binding until there is a final signed agreement, because you do not want the tenant to claim that there was some sort of an understanding that because you were having these conversations that they did not have to abide by the lease. And you want to have a clause that says that all lease terms remain in full force and effect until such time as there is a signed amendment or addendum to the lease. Next, you want to sit with your lawyer and look at what does the lease provide? What are the tenant's rights? One of the most popular arguments being made by tenants in these negotiations is that there's a force majeure clause. A force majeure clause is a clause which essentially provides that under certain circumstances, acts of God, whatever, earthquakes, that the tenant is not obligated to perform under the lease because of that incident, that force majeure, whatever it is. But there is No one standard force majeure clause. A lot of times these force majeure clauses are heavily negotiated, so you cannot assume that whatever force majeure clause you've seen before, that it's going to apply to your situation. That's something you need the lawyer to take a look at. Also, even if there is not a force majeure defense, the tenant may try to argue an impossibility or impracticability of performance argument. In California, that would be Civil Code sections 1441 and 1511. Again, in your state, you may very well have a similar clause, a similar statute. So you need to talk to your lawyer in your city, in your state. And then you want to take a look at the lease and see what are your rights. Usually, you do have a right to terminate and sue, and or you have the right to collect rent when it becomes due. Again, there are certain statutes in California that need to be complied with in order to make sure you have those rights. So again, you need a lawyer to take a look at that because, again, you don't know what those statutes are and you don't know if you're in compliance. And the next thing you want to think about is what changes do you want? Because think about it. If the tenant is coming to you, asking you for major changes to the lease, as far as I'm concerned, whether I'm a landlord or whether I'm a lawyer representing a landlord, is all bets are off. That means that if there's anything that you wanted in the original negotiation with that tenant, but you had to concede on in order to get the deal, as far as I'm concerned, all bets are off, and you can go back and you can take a good look at the lease and what your experience has been with the tenant, and what changes do you want if you're going to be providing a concession or a compromise with that. Hold on a second, sorry. What if you're going to have to enter into that negotiation? What changes do you want as a landlord? So think about that. Next, you want to consider what are your legal rights under federal, state, and local coronavirus orders. As I mentioned earlier, in California, we have a local ban on commercial evictions. And right now, the courts are starting to open up, but there are still restrictions. And again, there is no unlawful detainer summonses at this point, and it won't be for a long time. So what is going on in your state? You need to find out. Next, you want to think about what are the practical difficulties of getting another tenant in place. Before you get too aggressive with this tenant, what are you going to do if the tenant leaves? You have to think about that and decide if that's something that you want or if you want to somehow make it work with this tenant. And ask yourself, do you want to preserve the relationship with this tenant? I've had a number of clients who come back with responses that are not necessarily what you would think they would want to do, but this is what they do. I have one landlord rather, who decided that they wanted to work with this tenant and give more concessions that I recommended because they had a good relationship with the tenant, which is understandable after a number of years. They don't want to come down too strong against that tenant. So is that true for you? If it is, then that's something that's going to guide your negotiation. Is it because the problem is temporary, either because this is a tenant whose business is coming back, or because the tenant is a major tenant that is having a tough go right now, but in the next few months, you expect them to rebound for whatever reason, or because of lender requirements? We're going to talk about this more in a second, but you have to check your loan documents or have your lawyer check your loan documents to see what restrictions there might be imposed by those loan documents on what you can and can't do in connection with your tenant. Very, very important. So don't forget to have your lawyer take a look at the loan documents. If the answer is yes, that you do want to preserve the relationship, then what you want to start doing is working with the tenant toward a creative solution. Again, letting your lawyer be involved either in the background or taking the lead on this. And you want to get the tenant's financials. You can talk about a full or partial abatement of rent or a deferral of rent. And if you go with either of those, there are multiple options for the duration, multiple options for repayment. And again, you want to get it properly documented. Again, you also want to coordinate with your lender, as I just said. Consider the covenant waivers and modifications in your loan documents and whatever loan modification options you might need to get in order to make your compromise with your tenant work. We don't have time to go deep on the insurance question, but you should check with your insurance broker, and you can also have your lawyer, and this is one of the services we provide, review your insurance policy to see what it might provide for you. Business interruption insurance is the usual Plan A option, both in your policy and also in the policy of your tenant. So you want to take a look and have your broker and lawyer take a look to see if you have business interruption insurance and if that might help you in this scenario. I will tell you that in most cases, the business insurance is not going to apply to this, but I'm mentioning this anyway because it is important. Again, there's not one size fits all when it comes to the insurance policies. And so if you don't tender the claim, then you could lose the option to do that later because of the statute of limitations. So this is something, again, that should be on your checklist of things that you have to make sure you're addressing, because if you do have insurance and if you didn't tender the claim, you could be spending way too much money that you don't need to spend because you do have insurance. So you got to check that out. So in summary, let's talk about the action plan for you as landlords. Number one, you want to get the lawyer involved early, and you want to consult your lawyer to review your lease, your loan, and other relevant documents and understand your strengths and weaknesses and limitations. You want to consult with the lawyer to understand existing and proposed orders and laws that may impact what you can and cannot do, and to understand if your insurance may provide relief and to make a claim, and to get the pre-negotiation agreement with the tenant and help you identify all potential alternative solutions. You want to make sure that you're using best practices in marketing your vacant properties if that's what you're going to be doing, because there are a lot of restrictions in what you can and can't do in marketing your vacant commercial properties. So if you have questions or need assistance, we are here to help. And what we can do for you is prepare a customized action plan to make sure you're covering all the bases. Everything we've been talking about today is obviously on a general basis. In your situation, there may very well be additional or different action items on your action plan. So that's one of the things we do with our clients, is prepare a customized action plan based upon your unique facts. We can do a lease analysis to make sure you understand your strengths and weaknesses. It's important that you understand both. We can do a loan documents analysis to make sure you understand what you can and can't do. We can perform an insurance analysis to determine if you have coverage to help and the best way to submit your claim to increase the chance of your carrier providing coverage, because in a lot of situations, it all boils down to the language you use when you submit your claim as to whether or not you can qualify for the coverage. We can prepare your pre-negotiation agreement. We can negotiate, mediate, arbitrate, and litigate to protect your interests. We can prepare a compromise lease addendum, which you'll need if you're going to go forward. We can prepare a rent deferment agreement, prepare a rent abatement agreement, and prepare a loan conversion agreement. One of the other options you do have, is instead of doing a rent deferment or rent abatement, convert whatever the tenant owes you into a loan. And that way, if you want to go after them later, it's a cleaner action to go after somebody and collect on a loan agreement. So if you have any other questions, we're here for you. There's my information at the bottom, Jeff Lerman at 415-595-9090. There's my email address and our website for our law firm. So with that, Marty, there you go.
Jeff, this is great stuff. Do you have any perspective on, how long you think this cycle is going to be in California? I mean, given your experience with the 2009, 2010?
Yeah, well, not only that, but we talk to a lot of brokers in our community. And so we keep our finger on the pulse that way. And what we're hearing most people say is everything really ultimately rides on when a vaccine or some alternative that has the same effect of a vaccine gets created so that people get more comfortable in being out in public. And so right now, the only thing that we can go by is the estimate that it's going to be in Q1 of next year, maybe Q2 of next year, for a vaccine to come to pass. So if that's true, we're looking at being in this thing for another year. And I think that you need to assume that that is what you're going to be doing.
Interesting. And looking at the economy of the Bay Area, and I mean, I think that the underlying companies are pretty have great fundamentals. So, are you the same mind? You think that obviously you've got the Facebooks and the Googles of the world in your area. Any thoughts about that in terms of the general fundamental underpinnings of that economy?
It goes into two categories. There are businesses that without question are benefiting from what's going on here, and there are businesses that are going out of business because of what's going on. And I've seen interesting infographics that are identifying those industries and specific businesses actually. And I think it's going to shake out along those lines. I mean, obviously, as a couple of your earlier speakers said, restaurants are in for it. Gyms are in for it. Office. We were talk about irrational exuberance. The office market here in San Francisco has been on fire. On fire is an understatement. It's just been crazy for the last 10 years. But now, with everything going on here, everybody's that I'm talking to is expecting massive adjustment in the office market, not only because of what's going on now, but the concern that with what everybody is doing in terms of working from home, that is going to create a whole new dynamic in office. So this is, I don't want what I'm about to say to be taken the wrong way, but from a academic standpoint, it's a fascinating process that we are in, and something that in the 40 years I've been practicing, unprecedented, maybe in history. It probably is in history. And so that's it's fascinating from that standpoint. But the reality is that this is such a huge game changer, and we really don't know how it's going to end up in terms of who's going to survive and where ingenuity is going to come in. But this is where we're at.
Right. I mean, if we look at the last cycle, there were so many workouts, and I expect this to be longer to take, to work everything out and to see where things are going to go. So, well, listen, Jeff, again, to the audience, I mean, Jeff's been a fantastic supporter of our group for many years in the Silicon Valley area. Thank you so much for the presentation. And I think you had some fantastic words of wisdom here. So we'll send out your information to all the different registrants, and they'll contact you if they want to get information from you. And so just to get back to where we are, so we're going to be in Austin, Texas on July 28th. We've got a full day forum there. We have about 250 to